23 at 1 p.m. This is a public meeting under Hawaii Sunshine Law, which we are conducting in person as well as Zoom, and this meeting is being recorded. To start the meeting and to document in the minutes, I will ask members to introduce themselves with their name and their organization if applicable, and then I'll also give people in the both in-person audience an opportunity if they would like to introduce themselves, as well as our participants via Zoom. My name is Bill Kunzman, and I'm the Deputy Director of the Department of Labor and Industrial Relations, and I am also the Director's designee as the co-chair of this board. So maybe we can go to my right.
Good afternoon, everybody. Louis Oliveria, Deputy or Director of the Department of Budget and Finance. And also co-chair.
Andrew Nomura, formerly retired. Retired 3 months ago from work.
Hello, Brian Taniguchi, former state senator and a retiree.
Happy retiree. Hello, everyone. I'm Sharon Moriwaki. I'm Senate Chair of the Labor and Technology Committee, successor to Senator Taniguchi.
Aloha, everyone. I'm Jesse Kilomclenny, and I am the business representative on this board. I'm the CEO of the King Honolulu Trust.
Barbara Creek, I am retired and I am on in this seat safeguarding the interests of employees.
I'm Karen Yasukawa, safeguarding the trust of the concerns of the employers here. And I am actively working as an investment consultant with Raymond James.
And I'm Jade Butai. I'm the Director of the Department of Labor and Industrial Relations. And I looked at the composition of this board, and you're only as good as the company you keep. And I think we have a good company. Thank you.
Okay, and maybe a little bit of housekeeping moving forward. I apologize. We have 2 mics. If people, when they speak, if they could grab one of the mics, that way we can make sure everybody on Zoom hears. And with that being said, I'll give the mic. I definitely want our representatives from the Department of the Attorney General. They've joined us today to be available for any questions. And anybody else who wants to introduce themselves.
Hello, I'm the third Mike. I'm Mike Moyama from the Attorney General's office last year.
I'm Stacey Truvia, also from the Attorney General's office.
I'm Audrey Sigalakagal from AARP. Aloha, Kelly Lopez, also with AARP.
And I'm Kim Olson with the Pew Charitable Trust.
Okay, thank you, everybody. And our folks on Zoom, would you like to introduce yourselves? I see Tom Heinrich. I believe you may be on mute. Tom, can you hear me?
I can hear you. Can you hear me now?
Yes.
Okay. Tom Heinrich, now on staff with Representative Della Bellotti and former legislative assistant to former Senator Brian Taniguchi. Welcome.
Thank you. I also see Charles Izumoto.
Hey, Charles from Senator Moriwaki's office.
Thank you. Kevin Simon. Okay, if you want to introduce yourself later, you may, Kevin. And we also have Karan. I don't want to butcher your last name if you want to introduce yourself.
Hello, my name is Karen Siddiq from AKF Consulting Group.
Thank you. And also we have Angela Antonelli.
Hi, everybody. Congratulations on this board meeting. I'm the research professor and executive director at the Georgetown University Center for Retirement Initiatives. And one of our primary missions has been over the years to help advocate the creation of the state facilitated retirement savings program. So we're very happy to see Hawaii. And in 2023, you've now been joined by an additional 2 states. So we have 18 states across the country with the addition of Minnesota and Missouri so far this year. So again, congratulations and thrilled to see this board meeting. Thanks.
Okay, well, thank you, everybody. Thank you very much. A couple of notes before we dive into the agenda. For everyone's edification, I guess, we did have some communication with Speaker's office yesterday, and they're still in process of appointing the ex officio member from the House of Representatives. And we have quite an ambitious agenda today. So we should probably dive right into it. We'll try to take a break, maybe about 10 minutes, maybe between the agenda items 3 or 4. And since our Director of Budget and Finance is here, if we can take part of the budget agenda item out of sequence, so he can talk a little bit about the budget. There was a House bill, there was a housekeeping measure of sorts having to do with the maintenance of effort. I don't know, I'll turn it over to the director to explain that. He's a little bit more educated about that than I. You want to look at that particular page? Yeah. We can go to that page.
Sorry, it is the section, there's no page number, but it says budget. Apologize for going a little bit out of order here. I do unfortunately have been called to another meeting that I am unable to get out of at 1:30, so I have to leave at 1:30. We are really at the beginning and the establishment of the Hawaii Retirement Savings Program. You know, we are looking at executing. All of the funds have been appropriated and they are available for release as we kind of put through and start to constitute the actual program itself, including the the staffing and any type of other type of OC. But one of the things that I really wanted to talk about, and if anybody had any concern, was the $25 million infusion into the Hawaii Retirement Savings Account. So that money was appropriated last year for deposit into the special fund for the Hawaii Retirement Savings Program. But because of an issue related to the maintenance method, it has nothing to do with the Hawaii Retirement Savings Program. It has everything to do with the state's commitment to ensure proportional share of expenditures between educational expenses that we get from the feds, as well as any other type of expenses. So this particular program, the 25 million, what we did is we went into this previous legislative session and we asked that instead of depositing those funds in fiscal year 23, which literally ends in 6 weeks, is that we would make the deposit in fiscal year 24, where we no longer are under the federal requirement for maintenance of effort. So the money will be available. I did talk to Bill Klinsman about it. And as soon as we start the fiscal year 24, we should probably put that into the first quarter allocation and then just go ahead and make that deposit into the Hawaii Retirement Savings Program. So does anybody have any questions? If you do, you can call Bill.
Our operating budget is all intact for this year and next year.
Yeah, correct.
Can you confirm, do those monies go into a trust?
So,
You hear me then? No, it was not.
Yeah.
Those monies, are they deposited into a trust account? And is there any restriction on the year in which they're spent?
So from my understanding, it is a special fund. So, you know, Bill and I were actually talking about it. Maybe we might want to look at some legislative, fix in the future and turn it into a trust account, which has a little bit more protections with regards to the utilization of the fund. But once those funds are deposited into the special fund, they stay there until such time that they're expended. They are no longer subject to lapsing.
Thank you.
Yeah.
And, if we, I know the special fund, there's always a 5%. There's a 5% that for you get charge for general services. Can you exclude this from that charge?
So there are specific provisions and actually there's statutory language that actually identifies special funds that are not subject to the 5% central service charge. I'd have to take a look at it, whether or not the retirement savings special fund does fall into that particular category, if there is not that exemption, but I could, honestly say if there's not, then, from a budget and finance perspective, we would support putting in legislation in the future to just exempt them from the central service fee.
Okay, thank you. Okay, now we can turn to our first presentation. This is on a little bit of the historical background for how this initiative came to be and the act and the law and the reason why we're having this meeting today. So I'll go ahead and turn it over to Kaylee. She's going to do a PowerPoint presentation. Yeah.
So, hi, everyone. As I indicated, I'm the state director for ARP Hawaii, and I appreciate being asked to provide and participate in the start of your first board meeting. So one of the things that's important to know is that for about 7 years or so, ARP had been working with the legislature, especially more recently with Senator Taniguchi and Representative Onishi. The key piece here is that Hawaii, that the legislature and many of the advocates saw that Hawaii was in a retirement crisis. So several things that occurred, and I'm going to go over very quickly, only because one, I think you have more important issues, but also some of you are already familiar with a good chunk of this. So in 2021, one of the things that the Senate was able to pass was a Senate resolution that allowed for a task force. Then throughout 2021, the task force met and provided recommendations for legislation, which was passed in 2022. Next slide. One of the things that was clear as the Senate looked at the Senate resolution was the concern about retirement assets and the fact that much of the assets that many retirees were relying on, much of it was retirement, Social Security. And what you can see from this information is that one, limited retirement savings outside of Social Security. You add in Social Security, but then look at what the average expenses were of someone that's 65 and older. They're just barely making ends meet on that. And so the concern was that this data was predominantly from people in our later age group or our age group, which are known to actually be better savers than the younger folks. Next slide. So what was clear from much of the studies that had been done was that a retirement savings where people can save directly from their paycheck, people are 15 times more likely to save. And then also if they're automatically enrolled, they're even 20 times more likely to save. So it was key to ensure that people who do not have access to retirement savings through their employer, that in fact that be something that the state looks at. Next slide. So what the resolution did and called for was that the task force look at what it would take and what's the feasibility of having a retirement savings program in Hawaii, similar to other states. At that point in time, we're looking at Oregon, California, and Illinois. All three had a very active and robust programs going. And then what would the implementations requirements be? And so those were incorporated into proposed legislation and the framework and what it would take to start it up and what the costs were. One of the things that the task force recommended, we can go to the next place. Let me talk about the task force. So similar to this board, there was a requirement that the participants on the board, on the task force represented different groups. And as you can see, we had someone from DLIR as well as BNF. Tina Yamaki was with the small businesses. We had Senator Taniguchi and Rep. Onishi, both with the labor chairs for the different houses. And then we had folks involved in primarily in investments, although Jeff Gilbreth primarily focused, and why we had him on was a focus or concern that some legislators had about whether people were too poor to save. And Jeff happened to work with a lot of, in his case, predominantly Native Hawaiians who were saving for down payment on Hawaiian homes, but had a great deal of experience, in fact, demonstrating that actually, if you attempt to save, even if you only are barely making ends meet, it's something that can be accomplished. Consultants that we had, the task force had were Lisa Messina from Messina Associates and John Scott with Pew Charitable Trust, and then the administrator. Next slide. So what the task force wanted to ensure that they had, again, part of the issue was the task force report was going to have to provide critical information to ensure the legislature recognized that, in fact, passing the retirement savings plan was a good idea. So several things that were done. One was that the task force had SMS Research do a survey of 700 retirees. AARP had already had in plan and had surveyed 300 small businesses in Hawaii. And then Pew Charitable Trust also funded a study that included basically, I'm not sure we've made it available, but should make it available to the committee members, was the cost of doing nothing. Basically, the potential impact of insufficient retirement savings. And basically what it showed was that there would be, not that this program alone in of itself would make a significant difference of the $1.2 billion shortfall over the next 20 years if nothing was done. And also what they found with the owners is that many owners, in fact, did want to be able to provide retirement savings to their employers. But the big factors for why they weren't was that it costs too much, that it's complex, and that they would have to take on liability, fiduciary liability for those programs. And then what we also found from workers was absolutely they were interested in retirement savings, were interested in finding an easy way to make that happen. Traditionally, what we had been hearing from those who were opponents to the retirement savings program facilitated by the state was that, in fact, people can actually today go into a financial or work with a financial investor and open up their own IRA right now. The challenge is over the last 40 years, what we've seen is only about 20% consistently over those 40 years, only 20% of the people out there will actually do it. Next page. What we found though, and why this was important, although the task force did not commission this study, it was brought to the task force attention, the Hawaii generational economy, and what it looked at and where it was important and coincided with this issue of retirement savings was the fact that it showed, one, the trajectory of older people in Hawaii, that's going to continue to grow. But the other piece it also showed was the decrease in the number of tax payers. And what that means is fewer young people. So the concern is as we age, and if the cost for us increases, predominantly medical or other issues, that if people don't save enough, they actually will need social services. And then the tax requirements to fund those social services were going to be borne by a smaller pool of taxpayers. So the critical key piece there was, it was very clear that it wasn't just important to the retiree, to older people, or in this case, younger people who are going to get older, but it's important to everyone else, right? It's not just those who are saving for retirement, it's those who have to cover the cost for people who haven't saved. So that was a critical piece. And one of the other things that I think the task force did a great job about was, once they were pretty clear about what the proposal was going to be, presented 2 business roundtables to share with business owners what the proposal was going to be, as well as financial service institutions. We wanted to make sure banks and such knew what the plan was, so that, we have no idea who might be interested in actually competing for the potential contract. Next page. Maybe that slide's in there twice. Yeah, that's the one. So after that, really the next piece that occurred was legislation was introduced last year. We can go to the next page. So what was key out of this process was the task force had recommended legislation. They worked closely with Senator Taniguchi's office in particular, to come up with draft legislation. And it basically was to, in fact, establish this program, provide a state facilitated payroll deduction for individuals. Now, the key piece here is that it's a mandatory program. Any business that does not already provide retirement savings to their employees are required to have make this program available to their employees once the program's up and running. There's some issues that will come up later around the definition. How do you cover, what's an actual covered employee? And that'll be an issue that you'll be working with, whether it's the AG's office or someone else. And then it authorized, as part of this process, I know work that Bill would like to see happen, which is an evaluation study, implementation strategies. So we put some of that's in the bill and calls for the program to be stood up. Next page. I'm sorry, I put the mandatory employee part here. One of the things that changed in the bill was the opt-in requirement. Consistently, the task force was clear that most successful programs are opt-out programs, meaning people are automatically enrolled and they choose not to participate. That's much more successful than an opt-in. And even programs that have employer match, where people have to opt in, they will choose not to participate. So there was concern about what that might mean, especially for people who, what the legislature called the ALICE population. Well, they didn't call it that, but what they utilized was the ALICE population. And those are basically people who are asset limited, income constraint, and employed. A nicer way of being working for. That they would have challenges if the automatic deduction occurred and they weren't paying attention to their paychecks and not realizing that money was being taken out and perhaps impacting their finances and budget for their family. So that got changed as a way to address that, and the concern was the introduction of the $25 million. So the thought was, if people have to opt in, have a matching fund of $500 for the first 50,000 participants. The reason the 50,000 participants was important was in order for the program, and people here at the table, all of you probably have a better sense of, you need a large volume of participants in order for the program to be financially feasible to move forward. In addition to that, they recognize the need for financial literacy, which is what the 1 million is for. That's the one that I think will be a bummer that lapses and maybe worth looking at again if the board's interested. an appropriation for that out of next year that enables that. Again, a big concern for the legislature for when this was introduced was around those folks who might not understand the importance and value of saving. And again, I think whether it's opt-in or opt-out, this makes a lot of sense. And I talked about the fact that there's a need to look at covered employer going forward. Next page. So and the other thing, as you know, is it established this board, this 9-member board, and I don't need to say more about that. And to wrap up, some of the things that are also included was it originally started with just an executive director with DLIR's input, which I think was important, added 2 more staff members, and it also allows the board to contract professional managers for the financial investment side of things, as well as for the records management or the administrative side of that, which is what many of the programs that are out there have. And then just something you will know as a group having to submit annual reports to the state legislature each year. That's it, unless people have questions. Okay. Thank you.
Okay, thank you, Kaylee. That was an excellent, concise overview of the genesis of this project. It was, there's a lot of moving pieces in this, and it's a little bit more complicated, but she eloquently explained how we got to where we are today. So thank you very much. We wanted to take this opportunity to both kind of make sure that the board was aware of what statutory provisions applied to the board as a general rule of thumb, and also that's in particular in Act 296. And then also take the opportunity to explain and have the ability to ask some questions if you want about what the actual statute provides for as far as what your powers and duties of the board are. So without further ado, we can move on. Next slide. So Chapter 84 Hawaii Revised Statutes is standards of conduct. That's the ethics provisions in our chapter that apply to all boards and commissions. That law does require everybody within 90 days of starting with a board to do a mandatory training. It's available online, self-directed, covers those topics. And I believe that you all were contacted by the Ethics Commission because the financial disclosure requirements also are supposed to be done within 30 days. Is that not true?
No.
Oh, when I talked to them last week, they had told me that they had contacted everybody at the board to.
Nothing.
Oh, okay, I'm sorry about that. So after this meeting, we'll for sure get you the information because the law requires people to file their first financial disclosure statement within 30 days of being confirmed to a board or commission, and today happens to be day 30 from your confirmation. So sorry about that. When I had communicated with them last week, they had told me that they had emailed everybody or otherwise contacted them and that they were going to follow up with you folks. So evidently there's some kind of miscommunication.
There's no communication.
Yeah.
There's none. You were even know, for me, as a brand new person to this, I didn't even know that was a requirement. Not when we said anything.
Okay, well, we will, right after this meeting, we'll get the information to you folks, so. we
Should
can-
the ethics commission know that it was more miscommunication?
Yeah, we'll also contact the ethics commission as well and let them know.
Yeah.
So that initial financial disclosure is also required on an annual basis as well. The statute itself that was put into place by Act 296 also has specific provisions for this board because there are, I guess, not, I don't know what the right term is, but you do have some responsibilities in regards to financial things to make sure that there's no conflict of interest in your participation as a board member. The Hawaii Sunshine Law is in chapter 92 Hawaii revised statutes. And it prescribes how boards operate in a public fashion, essentially. And with the limited exemptions, it requires that all discussions, deliberations, and decisions regarding board business must be conducted at a board meeting, no communications between members. There's public notice requirements, which is our responsibility as the facilitating department to do, to make sure that the meetings are open, that we do the 6 days notice beforehand, that we accept testimony, and that we post minutes. So what the law currently provides for the minutes is that as soon as practical after the meeting, because this meeting is being recorded and there's Zoom participation, we will post that on our website on the board's page that we've created until such time that we're able to post the minutes, and then we will post the minutes and take down the recording of this meeting. Any questions about those two laws? Okay, so to reiterate a little bit about what Kaylee was saying about the setup of the, oh, sorry.
Can I ask a question?
Sure.
About the meetings on page slide before? Because I don't know. So
Sure.
when you're saying no communication outside of the meetings, that means I cannot get together with Barbara and talk. Is that what you're
It's
saying?
not about anything pertaining to business for the board. So you can socially talk to her or whatever, but you can't talk to her about things that the board has jurisdiction over, a topic related to the board. Any kind of, I believe the term is board business.
It's a very broad.
Yes, and the Office of Information Practices that administrates this law is very strict about it. There is an exemption that's available under the statute for what is deemed research purposes. And this may come into play for this board as we go on later in the agenda, and throughout this discussion, there was probably going to be legislation either next year, probably next year, and on an ongoing basis. The law allows for a permitted interaction group, which is 2 or more members of a board, but less than a quorum, to be able to do some things, including discussions about items, as long as it's publicly noticed in an agenda item that there is going to be a permitted interaction group. It has the unfortunate acronym of PIG or PIGS, but then that does allow board members to conduct business outside of a regular open board meeting that's open to the public for specific purposes, and then they need to report back to the board at a subsequently publicly noticed meeting. And at that meeting, the board is apprised of whatever the recommendations or conclusions or information that the permitted interaction group has, but cannot take action on that until a subsequent meeting. So it is kind of restricted.
So we just stay within our own head then.
For the board business, yes.
These permitted interaction groups, is that what that
Yes.
stands for? Are they, and these meetings, are they all required to be available online via Zoom? Or are PIGs allowed to be in person only?
Pigs can happen independently as long as it's agendized that there is the establishment of a permitted interaction group.
Yeah, and we can go back and we'll get back to you, but I don't think whether it's in person or Zoom, I don't think that's applicable. It can be either way.
It allows you to talk.
It allows,
discuss,
yeah.
And come back to the board after.
So there is a degree of, I guess, I'd say flexibility, but an opportunity to interact more within the permitted interaction group. Then the result was just essentially be a report back out in an agendized meeting at a later date.
So taking a So Barbara and I are talking
Yeah.
about this, and that's two of us. And if we are approved as a pig.
Yeah.
Then we do a report and come back to the meeting and report on our conversation.
So the, so
Yes.
the board will make a decision that we would like a permitted interaction group on this topic. They will select 2 or 3 of you
Yeah.
to come to a meeting, and you folks meet independently and do the research, and then you report back to the board saying, this is what the permitted interaction of the pig came up with, and then the board can vote on that, discuss that some more in the board, yeah. It gives you the flexibility in the pig to meet as often as you want, get information you want, in order to bring it back to the board for its decision making.
Thank you.
And I apologize, but I do have to leave, but, and the permitted interaction group would be different than a standing committee. So, and in this particular case, because we are talking about an establishment of this, I think the board would probably have to make the decision on, in a future date, possibly, this standing committees, an investment committee, an audit committee, a human resource committee, since they're going to be staff. So I think there's still a lot of work that needs to be done as we operationalize this board going forward, but we're up to a roaring start. Anyway, I do apologize. I do have to leave. I'm being called by my boss.
I have a general question about participation in the public meetings. So at this point, if any of us board members are participating by Zoom, I assume that counts for quorum and other purposes. It's the same as being in person, is that right?
That's correct.
And what about if, for whatever reason, we're somewhere where we don't have access to, the visual, but telephone participation? Does that count as well as quorum and other purposes?
I believe not, and we'll have to go back and double check. I believe it is required that board members are available both visually and auditorily in order to be a bona fide participant in the meeting. And I see the senator and former senator shaking their heads. So,
Right. Thank you.
yeah.
Let's see.
So, yeah, go ahead, Senator.
If we do, let's say, meet with the Oregon, their Oregon State's board, or if we meet, or if we go to a conference, do we have to make that as a pig? Or do we, or we can't do it, or we can't, only one person can go, or is that, the legislature is exempt from this stuff, so.
That's a very good question. I don't know if anybody has.
I think when you look at the law, it's if you're discussing something as a board of business, but if you're going to a conference and you're learning stuff and you're getting information back, I think it's a different kind of situation.
different
than when you're
provision.
making a decision on an item. Yeah, I think that's when you have to do it as a board.
Yeah, I think that's correct now that I'm thinking about it. Yes. Okay, any other questions about sunshine or ethics?
I just I was parliamentarian in high school, so I just want to make a point that because we're an open public meeting and we have people online, they cannot hear us without using the mic. So we really need to all speak into the mic.
Yes, thank you. That's a great point. And I will try to remember to ask people on the Zoom also have questions as we go on. Okay, thank you. So going back to Act 296, or also known as Chapter 389 now, and as far as budgetary items, so for temporary purposes, this program is actually in the general administration budget of the Department of Labor and Industrial Relations, even though the board is administratively attached to the department. And this particular board is actually in the director's office. And the intention is for the board, once they do hire staff, to be in the director's office until such time that circumstances change, either in the director's office or with the staff of the board, that then we would then find other space to allocate to this board. The law that was passed is think is a little bit easier than some other boards and commissions in that it just requires a simple majority of members for the quorum and for actions for a simple majority of that quorum to take actions. The decisions, this is a little bit different, but that is referring more to program things like appeals on benefits or things that pertain to rights and benefits. The law requires that that is dealt with in sort of an administrative law fashion where you need to have findings and facts and conclusions. But those do need to be approved by the board as a whole. So that may be a little bit down the line, but just so everybody knows. If you look at 3894, that is the section in the law about the board powers and duties, and it's quite a laundry list. It's 20 items. So we divided them up into sort of program related, which pertains to, you know, sort of the operations, and then the financial, which was more the investment side and things like that. It should be a little bit more convenient to go through. As Kaylee had mentioned, the law does provide for a program manager. It's a financial institution that needs to be done through Hawaii's procurement law. And the law also allows for interstate and intrastate collaboration in as far as investments, operations. The law is provides the board with some flexibility in that sense. And my understanding is that some of the other states have looked at this seriously, and that there may be some initial efforts where there are some states that are trying to work together to do this. And I know when we had the task force, this was one item that came up, and so that may be something that the board wants to pursue, because compared to some of the other states, we are a little bit smaller, and it may be a way to effectuate a program and have it done in a fashion that is something that would be beneficial to both the employers, the workers, as well as the state from a financial perspective.
Question, I'm not sure if it's for you, Deputy, but if the board were to decide to go into an interstate compact, is that decision, or that would that be subject to procurement, or is that outside of procurement?
Does the deputy AGs want to weigh in on that? I really don't know.
I am aware that if we were to contract with another Hawaii state agency, then that's outside of the procurement process. For example, if we engaged UH to do a task, but I just wasn't clear on what that means if we have a non-Hawaii but different state services.
I don't know what the answer to that exactly is. I don't know what the answer to that would be. We'd have to get back to you on that.
Okay, we'll make note of that and get back to everybody.
Thank you.
Okay, so on the program side of the ledger, there's some items that are important, of course. Among them, the program will need to determine the eligibility of the employer, the employee, or other individual. The program will need to comply with all applicable laws and regulations. The program will also have to establish procedures for timely and fair resolution of participant and other disputes related to accounts or program operation. For instance, if an employer feels like that this law doesn't apply to them, then they have to have a method to resolve that dispute with the board or the department. And the board also has the authority to cause expenses to initiate, implement, maintain, and administer from the program, to be paid from the program and other available sources. The board also has the authority to establish and collect application, account, administrative fees, to enter into contracts, to ensure that contributions are used to pay for benefits, administrative costs, and make investments. And there is a little bit of ambiguity in the way the law is written in a couple of the sections about how exactly to delineate between what is the contributions and what they may be used for administrative expenses. And that's something when I consulted with our deputy AG that they thought maybe could be done in rules, but it's an item that the board should keep in mind. We'll delve into greater detail a little bit later when we get to that, but there may be some question about that. And also the program expenses, the way the statute was written, is very specific in that the general funds that are used to initiate, implement, maintain, and administer the program need to be paid back to the general fund at some point. From the department's perspective, so we have this administratively attached board, and the way most of our programs operate, there are costs associated with overhead, indirect costs that we have in our federal grants and stuff. So for instance, if the department is going to be processing fiscal paperwork, there probably would need to be a MOA or an MOU between the board and the department in order to cover the cost for our fiscal section to do that, for HR functions, things like that. So at some point down the road, those agreements are going to have to probably be worked out between the department and the board. And on the department side of things, we're also going to have to be very careful to document and make sure we track all the expenses, because you know, all this money is supposed to be paid back to the general fund at some point. So questions?
On the previous slide for number 6, establishing procedures for the timing of is there an existing administrative hearings process that the board would be able to, you know, essentially latch onto and use? I know in some states there is essentially an Office of Administrative Hearings that handles administrative hearing for all state agencies, but I know that's not always the case, and I don't know what we have here.
No, the state of Hawaii is not set up like that. There's several different models for how that can be done. There's, I think they start on the spectrums from the more informal, something similar to what we have in our workers' comp, where it's an administrative hearing, but it's not recorded and it doesn't, so there is no record for, there's an appeal after that. It's at the Labor and Industrial Relations Appeals Board. We have some hearings in the department that are what they are called Chapter 91 hearings, where they're formal and they're recorded, for instance, for unemployment appeals. So there's models that the department does and that we're familiar with that may be applicable to some of these things, but frankly, I'm not really sure. We don't know how those other states are doing their appeals at this point. So
Just to add on to that, I have served on 2 boards of benefits programs while I was a state employee, both of which for informational purposes might be worth looking at what they have posted online to get a feel for how some of those issues are handled. So one of those is there's a public employees retirement savings program. It's called the Deferred Compensation Plan, or Island Savings Plan. It's administered by the Department of Human Resources Development. And what is very helpful, I mean, I refer, as I was monitoring sort of the task force to get involved in this program, I've referred back to that a number of times just to refresh my recollection. You'll see sort of how the program is set up in terms of contractors and who provides what services. So you can really get a better feel, I think, for what role the board might play. And also, I believe there have to be administrative rules there as well. And you can see how that program handles, you know, those issues. And even the other board that I served on was the EUTF, the Hawaii Employer Union Health Benefits Trust Fund. And that program, I think their rules would be quite helpful in terms of seeing how member complaints are addressed or how administrative issues are addressed and the levels that as Bill referenced, you go up through, you know, you first present your issue to here, and then if you're not happy, you can go here and those sorts of issues. And I think over time, I personally plan to be referring back to both of those programs as we work through at whatever point rulemaking and addressing, you know, sort of more of those details.
Okay, thank you. And I'd just like to take a moment to ask if anybody who's here via Zoom or in person, if they have any questions. I have a question. I believe if you're on Zoom, you can use your whatever device you're using to raise your hand, and that would indicate that you might have a question. So feel free at any time to do that, and we'll try to address your question. Go ahead.
Are board members open to any liability suits?
Okay, so the law itself provides for protection to some degree for liability for board members for various decisions. I forget which part of the law it is, which section of the law it is, but there is protections provided for in the statute. Whether that's 100% bulletproof or not, I don't really know. Maybe I can ask our AGs if they have their.
Yeah, I have to admit, I have looked at this issue, but and it also says that we have the authority to, if we deem it appropriate and necessary, to purchase additional insurance coverages. So I, for one, would appreciate if the deputy AGs could check that as well and come back to us with a recommendation. I mean, the language in the statute looks very clear on protecting the board members from liability. But if you can take a look at that, and if you would recommend that we do or do not look at, you know, especially down the line, at purchasing additional, you know, D&O liability, that would be appreciated. Thank you.
Yes, I believe Kaylee has a question or comment, because yeah, Barbara's correct. The law gives the board the authority to procure insurance to indemnify itself.
I just have a question, or wanted to double back on Karen's question about board members being able to speak to one another. I would imagine if I were on this board and we're covering things and I wasn't sure what all of it meant, I'd love to be able to turn to another board member and, outside of the meeting and say, I'm confused about what this means. Can you help me better understand that? I would hope that's not an issue. But if it is, it'd be nice to know who they're supposed to ask those questions of. Because again, not all board members are going to understand every facet of it. And I would hope that that's permitted. I do understand the concerns with the Ethics Commission is really the degree to which people are talking about a specific agenda item in particular and trying to come to agreement around what they think should happen, and those types of things are definitely not permitted. So one, just some clarification, because I would imagine that that's an issue. People being able to just talk to one another and try to help them understand all of what's in front of them. So would like to know that that's okay. And then the other is just a clarification around the permitted interaction groups. My understanding from what you said was that those meetings are open to sunshine, are subject to sunshine. Is that correct? And if so, that just for the permitted interaction groups to just know whether they are or aren't.
Yeah, I believe those are, but we'll get back to the board. My recollection from previous.
I think it's pretty informal.
It's pretty informal. Okay, we'll get back to the board, and I think Kaylee made a good point about informally trying to get clarification from fellow board members. I would think that's okay as long as it's not about board business. And for all intents and purposes at this point, because we don't have an executive director for the board yet or a secretary, feel free to contact either Nancy or I via email or via phone, and we'll give our office numbers, and I believe you have our emails already, but we'll send a follow-up email to this meeting. Feel absolutely free to get a hold of us at any time. If you have any questions or comments, please do so.
And we're gonna have the deputy AG on all the meetings, right?
That's correct. We'll have our deputy AG at all of our meetings, and you can confer with them at any time if you have any questions. Thank you. Okay, then going back to the board duties and powers and duties, there's also what we're calling the financial aspect of your duties and responsibilities. As you can see, this is pertaining to the actual mechanics of how the accounts, investments, and policies that the board is going to use to effectuate this program. That includes to, as mentioned earlier, not only the procure insurement against loss for the program itself, but also to indemnify the board members and also to collaborate and evaluate the role of financial advisors. In addition to the program manager, the law allows the board to procure consultants in order to be informed about how it goes about its business and how it effectuates the program. And then we also have a catch-all, take any other action the board deems reasonably necessary to carry out the purposes of the law. Any questions about that? Comments? Okay, and then as Kaylee had mentioned earlier, there is the thank you. The due diligence part about this. So the law as it actually passed was permissive to a certain extent that the board may do certain things, may do rules, may do a study or whatever. But it's our recommendation that the board go ahead and do these things like the detailed implementation and evaluation study. And the law sets forth a very particular progress or path for how the thing is to be implemented, because this detailed evaluation implementation study is supposed to result in legislation to be proposed before the legislature to include a budget, staffing recommendations, any change in the program parameters, the law, the statute requests, but we're saying better practice would be to require the board to look at the program parameters as set forth in the existing statute and make a recommendation back to the legislature of whether or not those program parameters are the most fitting for this program or whether some of those should be changed. So one of the big ones in the discussion with the task force and in the legislature at that time was whether or not this was an auto-enroll program or whether it was an opt-in. So that would be among the items that would be a part of the study and that the board would then take, and whether or not they would want to recommend back to the legislature. Actually, we went back and we studied this a little bit more, and we think it's a good idea to leave it as an opt-in program, or maybe the board would make the recommendation to the legislature, the best practice and what's been implemented in the other states is to auto-enroll, to have employees auto-enroll. So we're going to make that recommendation. Legislature, we think we should change the statute and enable that to be a part of the program, because that's really what's going to be the best thing for the state in the long run, as well as for the success of this program. Questions?
Yeah, so obviously, we have the task force report as the blueprint to the landscape of the entire program or types of programs. As I listen to you and read this, it occurred to me that if we were to do a formal, evaluation study, that there would likely be the need for engaging a consultant or consultants, similar to what AARP, is my understanding, did for the task force. What is our budget? Are there funds in the budget that could be used for that purpose?
There is, as a matter of fact, both in the existing budget, which is shortly to lapse, but then the department did go in and did receive approval from the legislature to have that money available in the next fiscal year. So there is $1 million in the budget for a study, and actually the budget worksheets detail that that's actually an actuarial study. So to include an actuarial study. So it seems like we have a pretty good amount of money to be able to go out and procure a study to include, you know, an actuarial component and other components to do all this stuff.
Thank you.
Yeah, and if we can go ahead and maybe take the budget out of order now, that seems like a good segue. And then after that, maybe we can take a break. And then we have another presentation by Kim Olson from Pew and the rest of the agenda. So as Louis had mentioned, the act itself did provide for approximately a $1.3 million budget for the implementation and operation. It included $1 million for outreach and education. Unfortunately, that money, that $1 million for outreach and education is going to lapse at the end of this current fiscal year. So that may be something that the board may want to look at as part of the recommendation back to the legislature. Legislature, you had intended that this program was going to be effectuated, that you would provide some general funds for the program to be able to use to do outreach and education for both employees and employers. So that's a future thing. And then the $25 million Louis referenced as part of the maintenance of effort was in HB 1018 this session. So the new budget bill that was just passed by the legislature provides for the $200,000 in the salaries, IT costs, and travel for the staff members and the board members, I believe, as well. If they want to do any fact finding or go to any conferences, things like that. One thing I'd like to note is that Kaylee's slide had mentioned that there was an executive director, an office assistant, and a program secretary in the budget. And when the department looked at those three positions, we actually changed the office assistant to a secretary because that seemed to be more fitting for the function of what that person would be responsible for doing and assisting the executive director. And also much more easily recruited to find a secretary than an office assistant in today's current labor force. So, but that is accounted for in the budget. So there is a temporary civil service position for the secretary, as well as the program specialist. And then the executive director is an exempt position. So that provides a little bit more flexibility as far as recruitment, salary, things like that. And we'll go into a little bit more detail on that in the later agenda item about that. So as I mentioned, Barbara referenced, there is $1 million in the budget for the fiscal year that begins on July 1st for the study. And then in the following fiscal year, the second year of the biennium, which would be July 1st, 2024 through June 30th, 2025, there is also the money for the salaries there. And then, of course, we'll probably look at if there needs to be any changes in the supplemental budget for the upcoming session or the subsequent biennium based on what the board's recommendations or deliberations are. We would include those with our departmental requests.
I have a question in the budget because we mentioned that we have to reimburse the state. So is the idea and what is the time frame that this gets spun off so that is there a fee that's going to be charged to those who come into the program? And is that how it's going to be going on into the future? I think even deferred comp, we get a fee, right? So how is that, or was it written into the bill that way, or is this going to be a state-run program? And I think that needs to be clarified as we go along of how we pay for it in the long run.
Yeah, that is to be determined, and I guess that's part of that feasibility study about how to sustain the program. And so that would be detailed out and would be deliberated upon by the board and then the recommendation back to the legislature. So
Yeah, I think, yeah, as far as how long it would take to reimburse the state for a lot of expenses, as well as keep the ongoing expenses going. There are a number of estimates that they're based on what we set up, in terms of what the fees would be, in terms of what minimum requirements we have and stuff. And so, I mean, we're talking probably at least 8 to 10 years before we can start to kind of scale things back. But I guess it includes the 25 million as we expect.
No.
Well, it doesn't include.
No.
That's right.
yes, any other questions?
That will be on the agenda so as we go forward, because if you're gonna do a collaborative with other states, you can kind of look at sharing expenses too.
Yes, exactly. That was, I think, one of the recommendations in the task force and the ongoing discussions at the legislature was that we facilitate to help implement the program with another state or other states or jurisdictions, because it would help defray the costs. So really, if you think about it, that the statute is permissive about this detailed implementation and evaluation study in the program parameters, but it is kind of critical, we think, for how to carry forward the board, and how it operates and everything like that. It would be critical to get that information, deliberate, and then make the recommendations back to the legislature. Is there anybody on Zoom who has any questions or comments? Okay, thank you. Well, yes, Gil.
The last bullet there says that the $25 million will lapse at the end of June next year.
Yeah, so I had asked Lucas about that, and he was gonna look into it and get back to me, because I'm not a fiscal person, and we're gonna rely on Lewis, but that was my read of what the bill said. So if that's actually the case, that's something that we would probably do in the departmental budget to extend the use of those funds if necessary in the supplemental budget.
It's a special fund. In the special fund. The fund was created.
They haven't transferred it into the special, so it's a general fund. We're gonna do it next year, so that
For the 2020, right?
Yeah.
Maintenance of it.
So that'll be another item we can report back to you folks on after Lewis gets back to you about exactly what that provision entails. Okay, anything else? Maybe we can take a short 10-minute break, come back at maybe 20 minutes after 2, if that's all right with everybody and everybody online. Thank you. It is now 2:20. Please get everybody back together. Before we get started with Kim's presentation, does anybody on Zoom have any questions or comments at this time? It appears not, so I'll go ahead and turn it over to Kim and she can do her presentation.
Up here. Hi, my name is Kim Olson and I'm the senior officer on the retirement savings project at the Pew Charitable Trust. There's my information there if you want to contact me. Can you move forward one slide? So I'll start just with a little overview of who we are at Pew. So about a decade ago, the trust decided that they were interested in this kind of taxing problem of understating in the United States. And the fact that you had what we look at it as about 56 million Americans in the private sector who have no access to savings at work. So the idea was, let's put together a research base and figure out what's going on there. How can we mitigate it? What would be the best way forward? Try and create some evidence so that we can find a good policy to move forward. So basically what we did at the trust was to do that research and then started looking at the state facilitated retirement savings programs that were popping up. At that time, it was Oregon, Illinois, and California, but we've seen that explode in the last couple of years. And determining, can we like look at these, see if they're working, and then determine if this is great evidence-based policy that we should be kind of advocating for. And in the last year, which is the reason why I ended up coming to the trust and getting hired, is because we decided, yes, we're going to pivot from this kind of research only posture to a research and advocacy posture. So I'm working with states that are implementing these programs. I'm also working with states that are legislating these programs to try to help put together rules, put together the best legislation possible to move them forward. In terms of tools, we still have a bunch of researchers. I'm not one of them, but we have a bunch of researchers back at Pew who do things like demographic research, financial feasibility modeling, and fiscal impact. And then, of course, I'm doing the things that are more like best practices and rules, regulations, and legislation. Next slide. Okay. So this is just a map of where automated savings are today. It is much more colorful than it was maybe even 6 or 7 years ago. So right now, operationally, we have California, Colorado, Connecticut, Illinois, Maryland, Oregon, and Virginia is in pilot and will be fully launched next month. So that's a good number of states that we have that already have functional programs. In terms of implementing states, of course, you've got Hawaii moving forward. We have Delaware, Maine, New Jersey, and New York. In the last 2 weeks, Minnesota and Vermont both passed legislation, so it's pretty exciting news. And then we have a number of other states like Massachusetts, Nevada, Pennsylvania, who are considering legislation. So it's, this is kind of something that's moving forward faster as like more and more states come on board, and it's like a proven like system for mitigating this gap.
So just
Sure.
so under the ones that are operational, it says under the ones that say operational, it says auto IRA. So all of them are IRAs then, and they're automatic.
Right. Okay. So
are there other models, or is that the model?
yeah. So at Pew we use the term automated savings program, but you can also people call it auto IRA. Like IARP calls it work and save. Some states call it secure choice. They all basically mean the same thing. I will get to this later. Like when we say auto IRA, generally we're talking about an employer mandate with an employee automatic enrollment. So Hawaii is like I'd still put you there under auto IRA, but you're a little bit of a unicorn in terms of of what we usually mean when we say auto IRA. Okay. All right. So this is just giving you some data on how the programs are doing. This is California, Connecticut, Illinois, and Oregon data. So Oregon did their pilot in 2017. They've been functional since 2018. The other states have come on board one by one. So we're seeing the money kind of start to flow in now. Registered employers just over 150,000. Savers just under 670,000. The assets are actually higher than that. Like in the last 2 weeks, it's 817 million. which is up 27% since December. So, I mean, we're starting to see these assets really start to increase. We should be seeing $1 billion in these programs this year, which is very exciting news for what was zero in 2017. On the average account balance, so the demographics for these programs tends to skew younger, tends to skew lower income, tends to skew, you see part-timers, you people that traditionally were underserved by the financial markets are saving in these programs. So, when you're looking at someone who's making $30,000 a year and they're putting aside 5%, it takes a while to start to accumulate money, which is why this average account balance is only $1,200, but it's $1,200 more than they had before, which is the whole point, right? And then that average opt-out rate that kind of varies by state right now, but this is for the automated savings programs, right? So the people that are being automatically enrolled. So we're seeing about 35% on average people saying, no, I don't want to do that and opting out of saving. All right. In terms of research, so this is all on the employer side. We did a small business survey in 2017, looking at a nationwide survey of small business owners, just asking them about a theoretical auto IRA program, because at that time there wasn't one in operation, saying, if this was offered to you, what would you think? Would you want something like that? 87% of small businesses said, yes, we would want that. And I think that was borne out in the data now with the operational programs. Because when we look at Oregon, the way that these programs are rolled out traditionally has been that there's been mandated dates that certain business sizes have to start offering a program. So like in Oregon, I think we started at 100 or more employees, and 50 or more, then 25 or more. But with those mandates, 1 in 4 Oregon firms signed up at least 90 days early. So it's not that they were waiting till the last minute and doing it because they had to. People were hopping in, like 1 in 4 hopping in way before they needed to, because there was actually this pent up demand to offer such a benefit. And they wanted to offer these benefits, but they just either couldn't afford them or couldn't administratively make it happen. So obviously the demand was there. We did a survey of Oregon State's employers in 2019, 2020. And we found that the employers were very satisfied with their experience, and even more so satisfied if they were small businesses. So again, looking at this, people who had, 5 to 25 employees either couldn't afford or couldn't administratively offer something, very happy to be able to offer a benefit for retention and recruitment. And then those who have started payroll deductions are even more satisfied. So those are kind of in the middle of getting themselves into the program, maybe a little less satisfied just because they're, getting through those administrative hurdles. But as soon as they're in, much more satisfied. Those last 2 bullets there, we asked the employers, are you finding that employees are coming to you with concerns about the program? And 80% said no, no one's coming to you with any concerns. And that's actually by design, because what we want is for those employee concerns to go to the program administrator. So the program administrator has a call center. Those call centers actually are in English and Spanish, and they can offer up to more, I think it's 200 plus languages that they offer translation services into. So they're pushing all of those questions away from the employer and towards those call centers. And then 79% said they incur no out-of-pocket costs whatsoever, which is again by design. The idea being that this is just something that the employer facilitates. It is not that they need to be taking on any kind of cost whatsoever to make this program happen. Question?
Is there any data? I know it's not in this study, certainly people designed this way, but is there any data on employees' concerns? Try to unpack that 20%, but separately, not part of this survey.
I would have to look back and see, because I was not at Q when we did that particular survey. So I'd have to go back and look and see if we have at least some like free form things on that, but I can look that up and get back to you. Yeah. Next slide. All right, so then we did some research from the worker perspective and found the exciting part obviously is that people are saving, right? Like that this is the population historically that was underserved, and they are saving, and they are doing it bit by bit, month by month, in a way that makes it automatic and easy to do. What we found, what we thought was actually quite interesting, was we looked at the pandemic and what happened in these programs, and we were looking specifically at the Oregon data. And we found that when the pandemic hit in March 2020, we saw a big spike in withdrawals, which is, makes a lot of sense. These are Roth IRAs. people can get to their contributions tax and penalty free. And that was obviously a time when people just suddenly needed access to cash. But what was interesting is then there was a precipitous drop off as soon as the federal money started flowing. So people just didn't take any more money out and just kept saving. So it wasn't that we saw people drop out. It wasn't that we saw them zero out. We saw them just keep saving after that point.
Just a quick question. Do all or most,
Sorry.
do all or most of the programs start with the Roth IRA?
Yes, every program thus far has done a Roth, and there's always like a board discussion. Do we want a Roth? Do we want a traditional? The reason that the plans have tended to landed on have all landed on Roth is because this is a population that really is concerned about access to their money. Whether or not they end up taking it, you know, it's more about like like they have a genuine concern about being able to get it if they need it, right? And so in a Roth, we can always, it's post-tax money. We can always get to it if we absolutely need it. Obviously, as a program, you wouldn't want to be like pumping people up to take the money, but it's nice to at least put it out there as a way for people to use it if they absolutely needed to, as opposed to, you know, taking a payday loan or something. Now, in terms of our survey of participants, we did this one in Illinois for the Illinois Secure Choice Program. And like the worker experience, we just asked them, you know, are you satisfied, neutral, dissatisfied with the program? And you'll see there 5% dissatisfaction with a government program. For anyone who's worked in a government program, that's pretty abnormal. So we take that to be a very good sign that there was pent up demand for a program like this, so that people could be saving out of their payroll and not have to like do all the machinations of trying to figure out how to save outside of payroll. And then this participation number, I will say that, you know, this survey was only done after Illinois has been had been running for 2 years. So it's a very short period of time that Illinois Secure Choice had been running at that time. But 38% of people said they felt more financially secure after just 2 years, or even 1 year. It's hard to know, like whoever decided to be part of the survey felt more financially secure, which I think is also a huge benefit to the programs, to say that, you know, people just feel like they're getting somewhere. Next slide. I mentioned at the top that we do fiscal impact work, and I think, and Kaylee mentioned this before as well, that we're looking at not just, you know, the worker experience or the employee experience, but also the taxpayer experience of knowing that we're watching our population age, the demographics are shifting, there are fewer workers for every retiree with every year. And so the pressure of not doing anything in this area is actually getting worse as we move forward, because we'll just have to have a higher taxpayer burden for all of the people who retire, you know, with only their Social Security and no additional savings. So we estimate, like we did a partnership with a group called eConsult Solutions, that they did some estimates, and they think that there's about 173,000 private sector workers in Hawaii that have no access to a savings mechanism at work. And that would cost the state a cumulative $1.15 billion in additional social assistance spending for things like Medicaid over the next 20 years. So, you know, if we take the calculations and work them, like it really is a very small amount of money that workers need to be saving, you know, somewhere between $100 and $200 a month to mitigate that number. So if we can just get everybody started, and hopefully we can bring that number down.
Has anyone looked at the impact of not having retirement savings and any relationship between that and adult protective service cases?
We've not seen anything like that, but I would imagine that there's probably a correlation. Yeah. Okay, next slide. All right, so that was the research, and now I'm just going to move into like best practices and lessons learned that we've seen over the course of looking at the programs that have stood themselves up in the last couple of years. So these are just best practices that we've observed from the different programs. You know, this is take it for what it is. Like these are just things that observations we've made. But you know, to this first point about rulemaking, so you know, for those of you who've done this before, I'm not sure how many have, but you know, legislation has a tendency to be pretty vague. There's, you know, it gives you the general outline of a program, but it's actually the rulemaking phase that is very important to figuring out how will this program run in practice, what exactly will the program look like, who's it going to affect, how will it affect them, and when. Those are all pieces of the rulemaking process. So when we get to the rulemaking process, what's important is that we think about the diverse voices we can bring to the table so that we all feel comfortable with a Hawaii specific solution. So, I can take you, from my experience with Oregon, we tried to have rulemaking advisory committees where we would bring in employer voices, employee voices, trade groups, other state agencies that had done rulemaking before to try to just get a bunch of people in a room and say, what do you think about this draft rule? How will this affect us? In Oregon, we had concerns from Christmas tree farmers who said, please don't enroll people right away because we have a 60-day window where we have a whole bunch of people cutting down Christmas trees. But then they're gone. We don't want to have to enroll them. So, I can imagine there may be sectors in Hawaii that have the same issue where it's like, hey, we would like you to wait so we don't have to enroll people that we know are just that kind of thing. So there's rulemaking. The other thing that's been a best practice for all the states thus far has been a pilot phase. And that's not necessarily just a pilot phase to make sure your technology is working, because the program administrators who are currently running these programs, they're pretty good at it now. They've got the technology going pretty well. But here it's really getting out there to employers, varying sizes, varying sectors, varying geographies, and getting them on board. So these are like the early adopters who will be able to speak to your program and tell other employers, this is actually working really well and I really like it, so that you don't have just your board or just your executive director running around the state saying, please, this is a mandatory program, you got to do it. Getting employers on board to say, this is working. If we all offer this, everybody's better because the rising tide is going to lift all boats here. And then to the outreach and marketing piece. It is expensive, and I imagine it probably is very expensive when you have multiple islands to cover, but it's very, very necessary because if people need to understand that this program exists first, that it's legitimate, like that, it's coming, it's not something that's just being an advertisement that is something that people should be concerned about, like, oh, I don't know what that is. If they see it enough of it, they'll start to understand that this is a part of of retirement saving in Hawaii, right? As opposed to, oh, I think I got this thing in the mail and it seemed like it was a piece of spam. We don't want that. We want to have enough people understand that this is a real program. Let's see, simplify the investment lineup. In this, I'll get to this under lessons learned, but most people are going to stick with the defaults. Like whatever it is that the board decides to set up in terms of the default savings rate, the default investment, like where that investment's going to go, all those things. They're not going to go in and change them. Like this is a population that is like this automation works well for them. And like all of these big scary decisions that maybe have kept people from investing in the past have already been taken care of. So you don't have to have 20 different types of investments here. Like you can have target date funds and maybe a couple of other things to make sure that you have the ability to come in and change up your investments if you want, but most people are not going to change anything. And then that final point there, and this is definitely this has been brought up before today, and I'm just going to put it out there with some information because this is definitely a board decision. But a best practice for these programs has been the automatic enrollment of employees. So Hawaii is kind of a unicorn here with that not being the case. But you have this voluntary opt-in, you have this matching contribution for the first 50,000 participants. But I will note two things. First, the private sector comparison, and this is just like with Vanguard's How America Saves. This will show you just a little bit about how different it is when we go from an opt-in to an automatic enrollment. So 66% of people were opting into a 401k with a match. So the match is also an incentive we don't have here with a Roth IRA. And then 93% of people were participating when it was automatic enrollment. And those numbers actually just get worse when you start to break them down by demographic. So you can imagine which populations where we get to the point where it doesn't look like that or it's worse.
Question.
Yeah.
Going back to your map of various states, how many states have that? Going back to your map of the states, how many states have any sort of matching program?
None. Because the way that this works is we're talking about Roth IRAs, and we cannot have an employer match into a Roth IRA or a traditional IRA. We just can't have employer matches outside of an ERISA plan.
I mean, so, but nobody's doing, this is not an employer contribution, this is a state contribution. Nobody else is doing that.
No, so this matching contribution is a brand new idea. I will say it is in some ways a little similar to what has happened at the federal level with Secure 2.0. Like we went from a savers credit to a savers match. The savers match is going to, we're not talking about implementation until like 2027 on that, but it would also be money that would go directly to people's retirement accounts. It's a very complicated thing though, so I'm not going to go too far into it. But no, this is not anything that's been considered in any other state that I'm aware of.
Okay, so just to summarize, our voluntary, our opt-in is unique and our $500 contribution is unique.
Correct, yes. Yeah, and to that last point, so on the federal level, when we have the Secure Act and then we have the Secure Act 2.0, which was passed at the end of last year. And in Secure Act 2.0, it has a provision that requires all new private plans starting in 2025 to use automatic enrollment. So plans that are already in existence have been kind of grandfathered in and they were not going to be required to do that. I would say ... yet, maybe we'll see. But in like when I see something like that, I'm just saying that it looks like that is kind of the new best practice, is the idea that automatic enrollment is what gets the maximum number of people saving.
Can you clarify what Secure 2.0 is?
It is, it's a federal act, like, yeah, through it was a congressional law. Right. Okay. Next one. All right. And then on the lessons learned side. So I mentioned that before, the defaults are incredibly sticky. And again, it has to do with the fact that when we do an automatic enrollment plan, like people are letting inertia carry them forward. So they are being enrolled into the plan by doing nothing. They have to take an action to opt out. So those that are letting inertia carry them forward are also not going in and making changes. So over 95% of people sticking with whatever the defaults are that we're choosing. So I put this chart over here to make that very clear. So this is what's interesting here is, so my CT Savings is the Connecticut plan. Their default savings rate is 3%. And so you can see their average rate is 3.35%. But in California, the default rate is 5%. So their average is just over 5%. And that's it, and we're not seeing huge differences, in participation. I mean, there is like a higher participation rate in Connecticut right now, but they are newer than California. So we won't know for another couple of years whether we see that participation rate change. But when you look at Oregon, the reason that they have a 6.5% savings rate is both that they default into 5%, and then they have an automatic escalation once a year. And so enough people have been carried forward that they are now, like that their average rate is now at 6.5, and that will just continue to go up over the course of time. So, what I'm saying here is you have to be very cognizant of those defaults, where you're putting them, and understanding that that you are setting the kind of the floor for all of the people who are in these plans, and that we're not seeing a huge exodus of people when they're defaulted to 5. And there are definitely behavioral researchers out there that say, actually, you could probably default people at 7 and they still wouldn't have a problem with it. And then if you default them at 10, like they won't necessarily opt out, they'll just change the contribution lower. So it's one of those things where, we're still learning. We're learning, when we did this in Oregon, and I say we because I was working in Oregon at the time when Oregon Saves was stood up. We went with 5% because we thought, yeah, I can imagine that people will stick with 5%, but it wasn't because we had a whole bunch of data behind us. So I think now that we're seeing this, you can make considerations about, would it make sense to change the default a bit higher? Maybe, who knows? So in terms of the people who have even viewed their accounts for Illinois, we have 41% of participants have ever viewed their account. So the majority of people are saving and haven't even gone in to look at it. I wouldn't say that's the best case scenario. It's great if people would know that they have an account and that there's money saved into it. But I think to that point that the defaults are sticky, people aren't changing it. They're not going in and making a bunch of adjustments. And then finally, that last point about the few adjustments to accounts post auto escalation. So both Oregon and California and Illinois, actually, what's not on that savings rate slide, they have auto escalation that happens once a year after you've been in the program. And we're not seeing people leave or change, like they just adjust. So, you know, we go from 5% to 6%, and they just roll over and keep going. So we're not seeing big changes. Oh, I'm sorry, go back. Can you go back one? Okay, so the other lessons learned here, access to employer data. This is one of the main issues for these programs, is making sure that you have the employer data, which, you know, I'm not sure where this is held in Hawaii government, like it's something to kind of figure out early. You know, in Oregon, we were looking at the Department of Employment, we were looking at Secretary of State. There are a couple of different places within state government that might have this, but you have to be able to contact every single employer in the state. So whichever like entity in your state has that access to that data, like you have to work with them to get access to it so that the program can run. Yes.
Did Oregon use a contractor to get the employer data? Or did you do it with the program staff?
Yeah, we basically made an interagency agreement with like the state agencies that had the data. And then when we pulled that together, then we gave the data to the program administrator, and the program administrator was able to reach out and do all the contacting. But I will say that it wasn't straightforward, and there was, you know, it was like we had to pull it from multiple locations, and it didn't all match up. So it's not perfect. Yes.
So I don't know where else it may be in the state, but our unemployment insurance division does have employer information. In order to be able to use that information, the board would need to develop a method or a memorandum of understanding or MOA with the unemployment insurance division. And since that's an entirely federally funded function, any costs associated with using that data to do mailings or whatever, the board would have to pay for, because it's not an allowable cost under the unemployment insurance program, but that would be one avenue.
Okay, so I think that is like one of the early pieces that the program needs to figure out is where's the employer data, and does that agency that has the employer data, are they going to let us have it? And if for some reason they say no, you can't have it, then you may need to go back to to your legislation and like to your statute and make sure that it's very clear that you can have it, because otherwise it's very hard to launch a program. The last couple of things here. Oh, go ahead. Sorry.
Did you identify, how did you identify employers who did not offer a 401k?
So early on, and this is again like these kind of like lesson learned things. Early on in Oregon, we were requiring basically all employers to go into the web portal and say, you know, no, I don't offer a plan. But what we realized a little later was that, you know, every business that offers a plan has to file a Form 5500 with the federal government. So we were able to look at the 5500 data, and that's still messy, like it's very messy, but we were able to look at the 5500 data and go ahead and exempt certain employers just based on the fact that they filed that form. But it's still problematic because you have businesses that use things like a professional employer organization, a PEO, and then, you know, it gets very messy about who's the employer and who offers the plan. So it's not 100%, but, you know, there are ways to kind of exempt certain businesses from having to do anything. And then there are other businesses you'll just have to reach out directly or have them go in and just say in the web portal, yeah, I offer something. Good question. The last bit here, so the enrollment waves have been condensed. Like in Oregon in the early states, we weren't really sure how long it was going to take, like, you know, what the influx of employers was, like how much hand holding we'd have to do. So there was, you know, like one wave every 6 months over the course of years, right? That's not necessary. You don't have to do that many waves over that much time, especially in, you know, with a place like Hawaii with this level of population. you can condense that and really just have it over a shorter period. And then these last 2 points, California has said that like formal outreach seems to be working the best to get response. And by formal, they mean use the state seal, make it look formal, make it look like a government program. People are responding to the government as opposed to making it look like something that, you know, could be an advertisement or something that, you know, like that someone might throw away. And then finally, you know, you have enforcement, it's in your statute, but we're finding that, you know, like enforcement can work without imposing fines. Like it just means that you have to, you know, reach out directly to these businesses and say, hey, this is in statute. There are fines that could happen eventually. We'd much rather in a friendly way bring you in as opposed to, you know, force it upon you. All right. And there's been a couple of words to this earlier, so I thought I would just take a moment here at the end to talk about multi-state partnerships. So, you know, this hasn't been tried yet. We have Colorado and Maine who have decided they're going to try a multi-state partnership. So Colorado is already established, Maine has not been established yet. So what I kind of see is like 2 versions of multi-state partnership as being possible. You can either have the, you know, I'm an existing program and another program comes in and joins my program. So that would be like, you know, in Oregon or Colorado or another state that's already existing that, you know, like Hawaii would say, I'd like to join with them. It would likely mean that you would have to take basically all the decisions they've already made wholesale. Like they already put all those defaults in place. They already have a fee structure. They already have a program administrator. You would just take all those things. The other one, and again, this is all theoretical, but like the other one would be to join forces with another state that's also implementing. So, you know, like a New Jersey or a Delaware or something like that. And then you would have to create this kind of coalition, multi-state partnership, and then do all those, you know, all those decisions. You'd make them all, but you have to make them together. So, you know, I don't know which one would be easier necessarily. I do think that in the first case with joining an existing program, your speed to market will probably be much faster because all those decisions are already made. You just have to, you know, seal that contract together with the existing state. Whereas the second model of establishing a partnership may just take longer because you have 2 boards and those boards are going to have to come to the same decisions and figure that piece out. So, you know, I think that both are theoretical at this point, so I think it's worth thinking about. But you know, like you're just going to have to work it out as a board and figure out which one you would rather do, assuming you go this route. So the statutory language has to allow a partnership. You already have that; it's in your statute. You need access to your employer data. You already know that that's important. You'll work on that. But I think to this last point on programmatic alignment, I think, you know, again, it's all theoretical still since we haven't seen this happen. But in order for this to make sense and to win efficiencies, like for the program administrator, for the programs, there's going to have to be programmatic alignment. Like you can't have a whole bunch of differences to the programs in terms of your defaults or your investment lineups or your fees. Like it's all going to have to be the same. And so to that first point, employer requirement, automatic enrollment for employees. You know, I just don't know. I don't like you're going to have to do that work to talk to the other states and find out whether they would be able to or willing to partner with a state that doesn't have this automatic enrollment piece for the employees. It's not something that is a known factor at this point. Question?
Instead of a partnership, I mean, is there any plan where there's a consortium or you know, with other states so they can learn from one another?
What do you mean by consortium?
You know, like it's, you know, because this thing where you're trying to have a joint, but you know, maybe you can just, you know, just learn from, you know, their mistakes or, you know, so you don't, you know, if you're going to make mistakes, it's going to be original rather than repeating the old ones.
Right. So Angela Antonelli, who's on this call right now for the Center for Retirement Initiatives at Georgetown, she runs a monthly call for the states that are implementing or interested in having a program where they do just that. They talk about what they're doing and they kind of share the lessons learned piece. But that's, you know, it's kind of an informal consortium. But, you know, this is more so like the idea of forming a partnership where, you know, your assets would create like an assets under management that are larger, faster. And then maybe you could push the fees down for everyone if like by accumulating that money quicker.
Could you just do a quick summary, please, of at least how Oregon works this, since you're most familiar with that state, in terms of what services are provided by which entity? Like, do you have the same entity that sort of runs the program, the enrollment, and also decides the investment options, or are those handled by different companies? And also, does Oregon have, or do any of the states have, that you're aware of, a financial consultant to help oversee the performance of the investment options?
Yes to all of these things. Like I would say at this point, all of the active programs have a program consultant, they have an investment consultant, they have an investment manager, they have a program manager, and that's just been kind of the norm. So like the program consultant has been the person who's been, or the company helping, sort through what are the decisions that need to be made, how are we going to make them, what are the best practices. The investment consultant is obviously like looking at how the investments are doing and giving guidance to the board. The program manager is like / record keeper is the one like actually running the program, because what the board is doing is the governance piece. The actual running of the program is happening, through this program manager who's keeping track of all the accounts and running the online portal and doing the call center work and all that stuff. And then the investment manager is the one who's, investing these funds and making sure that everything is running smoothly on the investment side. So there are a lot of moving pieces to this, but in a way that, that is a public-private partnership where the state doesn't have to take over a bunch of tasks that, they maybe are not well suited to the Department of Labor and Industrial Relations.
Just to follow on that and a separate question, but it's sort of like a deferred you contract out for a manager and they do all of that.
Yeah.
And how you select that in terms of the scope of work. And if you have that information, be helpful, I think, for the board. The second is in terms of the multi-trade partnership. You talked about Colorado and Maine coming together. What was that process? And did they try to do their own thing and then say, well, we better partner with someone else? How did that partnership come about? It would be helpful to know who would take on somebody else, and what does that take?
Sure. I mean, to your first question, I don't have a whole bunch of insight into, how that's worked. I think it'd probably be worth talking to an active state to hear a little bit more about, how that's working for them. To the second question, the states that are currently active, I think the ones that I've heard who are interested in partnership have been Oregon and Colorado. I'm not sure if the others are actively interested in that, but definitely Oregon and Colorado have spoken openly about wanting it. I'm not sure what Maine's process was for deciding. I know that they talked to different states about doing a partnership. And what that would look like, but in terms of how they made that decision, it'd probably be worth talking to Beth Borderitz, who's their executive director. And
Are there other partnerships, or is that the beginning?
This is the very first one. So originally, Colorado was looking at partnering with New Mexico, but to this item about programmatic alignment, New Mexico's statute was an employer opt-in. It was automatic enrollment for employees, but employer opt-in. And Colorado said, we're willing to do this memorandum of cooperation with New Mexico, but only if you change your statute so that it is employer mandate, because we just want to make sure that if we're going to do all this work to partner, that we're going to be getting, the numbers, right? And so right now they've had to kind of put that on hold because they were unable to change their statute this legislative session. So we'll see if that changes in the future. But at this point, basically Colorado and Maine have said publicly that they're looking to partner. I'm not sure where they are in the process of getting that going. Yes.
Is there some place we can go to or some document that summarizes the defaults for the different states?
I mean, I have a super spreadsheet on my laptop. I don't think I'm happy to share my super spreadsheet with you. Yes.
Take question for the
Sure. Yeah. Oh.
Just quick question. So I hear about the alignment, and my question for you is, Are there other states that have the payback requirement for the upfront funding? And if not, would the fact that that's included in Hawaii's program perhaps impact the ability to enter into a compact or multi-state partnership?
So I do know I can't say for sure that it's every state, but I do know that there are definitely several states who are required to pay back their loan. But like, as far as I know, there's not like a time limit to those paybacks. It's just it needs to get paid back at some point. So, I think all the states have been trying to structure their fees in such a way that it's not like the fees aren't too high on participants, but they are making enough money to like stop taking loans, get themselves to the point where they can function, and then like eventually get to the point where they can start paying it back. So I don't think that would be problematic. I think in terms of entering into like a multi-state partnership, you would just have to look at the fee structure that the other state has and then determine, like, is that enough for us, or are we going to have to tack on a little extra fee like for Hawaii so that we can get to where we need to go. Another question? Okay. So to the last slide. So, just in terms of like concluding here on the key issues to consider, for the board, I think with the opt-in that you have in your statute, if you're pursuing the opt-in, as is listed in your statute, you're going to have to kind of figure out how we're going to structure this to maximize uptake. Because that's going to be an issue that Hawaii will have that other states have not had. So like, what kind of marketing and outreach, partnerships, et cetera, will you have to create in the community in order to, get people to know what the program is and choose to take the action to opt. Same kind of thing with the matching grant implementation. Like it's going to be a process, right? Like, there's going to be applications. You are going to have to verify that people saved and how much they saved to determine, if they get the matching grant, how are you going to move those funds into retirement accounts? Like, there's a big process here that you'll have to figure out if you keep this matching grant. And the same with marketing for marketing and doing outreach and education and partnerships to tell people that it exists. Because, as we know from looking at things like the EITC, even though it's a program that actually would benefit, tens of thousands, hundreds of thousands of people, a lot, the uptake is not there in terms of people remembering that they have to make those applications and make it happen. And then, finally, I think that, your major key consideration is standalone program versus multi-state partnership. And if multi-state partnership, what does that look like in the term? So that is it. I will leave it there. We have signed a technical assistance agreement with DLIR. So Pew is here to help. We're happy to work with you on any questions you have about best practices. But we look forward to working with you.
Thank you. Good question. What was the time frame between Oregon's first board meeting and implementation of the program?
Don't make me think about that. Hold on. I feel like it was 2 years, but I'd have to look back and see how long it took. Because in the end, Oregon was like the first, right? So even just writing the program rules was okay. Well, there's nothing to go off of here. Like, no one's done this before. So anything that Oregon did, I can assume it probably took a little longer than the states that are currently standing things up because they have a roadmap. Yeah.
So if we were looking for a partnership right now, because we are, forget what we are, the unicorn.
Unicorn.
Well, we would have to still do our own plan because we're the only ones that are opt-in. And we are the only ones that are offering $500 for the first 50,000, right?
So I can't give you like 100% on those things. I think what I can say is that I think you would need to talk to the states that that already have programs and that are interested in partnering and ask those questions. And it would be kind of similar with the program administrators. Would they be okay with the meshing of programs that have those kinds of administrative details that are different? Like that, I don't imagine the $500 matching grant would be much of a problem because that would be kind of a like only to Hawaii savers that would, you know, be kind of separate, and it would be a whole application process that would probably be run through DLIR or somewhere different than than what the program administrators would do. But in terms of the opt-in, you're gonna have to talk to the states about that. Yeah. All right, no further questions. Thank you.
Thank you.
Thank you, Kim. Does anybody on Zoom have any questions or comments at this time?
Hi, everybody. It's Angela from Georgetown. Great meeting. Just wanted to highlight, Kim mentioned what we have at Georgetown as a clearinghouse. So for some of the questions that you all have asked, cri.georgetown.edu. It's a clearinghouse. So there's a snapshot document there, which has an overview of all the state programs. You can review the default contribution levels and other information about the state programs and snapshots. Also, Hawaii as a state has access to our login to review our state resource center, to a question, for example, about timeline from first meeting to launch. Generally, that's running about 18 months. The Oregon program was enacted in 2015, first met at the end of 2015, November 2015, and program launch was in July of 2017. All of that history and archives is available to the state, which can have an access and account to the Georgetown site. So there's data there as well. We collect all the state program data. You can see it compiled. And, you know, again, total assets, funded accounts, default contribution levels for the states that are reporting. And we will continue to add information as additional states like Colorado and Maryland begin reporting regular program data. So again, please feel free to use the Georgetown site, cri.georgetown.edu. I believe we've given access to the Georgetown site with some accounts for Hawaii, but if additional accounts are desired, we'd be happy to provide that.
Thank you.
Do you have the information on the Hawaii accounts for that website?
Not at this time. We'll have to follow up on.
Okay, thanks.
I can check my list and I'm happy to email and let you know what the accounts are. I just can't remember it off the top of my head, who we've given them to already.
Okay, thank you. And then I believe we may have had a question or comment from Tom.
Thank you. What I was going to ask about just real quick was a clarification or a distinction, if you will, in the slide on best practices, references made to Secure 2.0, requiring all new private plans to use automatic enrollment. Does that still allow for employee opt-out? Otherwise, there seems to be a little bit of consistent use of both automatic enrollment as well as opt-out for trying to gather as many of the employees as possible. Thanks.
Yeah, thanks for that. So this is like that's separate, like that basically means the private market for plans. So like your 401k, 403bs, employer sponsored ERISA plans are what we're talking about in terms of what's covered by the Secure 2.0 changes for automatic enrollment. So these plans are like these programs for the state are different. We're talking about a state facilitated IRA program. So that's just not covered by the same law that Secure 2.0 is. Go ahead, Tom. You have another question?
Yeah, just a comment. I appreciate that distinction. I was thinking about that earlier. And again, what it comes back to for my previous work here at the legislature on this act is especially for most of us, the interest in ultimately amending the act in order to be the opt-out model in order to try to catch as many. So there's a good group of us that would like to continue to work on that. Thank you.
Great.
Okay, thank you, Tom. Does anybody else have any questions or comments at this time?
I have a question. It's more a question of sort of political probability. What's the chance of getting that statute changed.
0 to 100. You know, I think there was, when we passed the, well, as the law was, as the bill was going through the process, I think there was a lot of support for it. And so I think that momentum and that support is still there. I do think, and I talked to Kim about this also, that we might need to get a couple of champions, maybe somebody from the House, somebody from the Senate, to really try to be the person that provides leadership to get the legislature, because you're going to need that. And then I think for us as the board, we have to decide what we want to do so that we can kind of amend the law, hopefully next session, with the things that we already set out. And, we have a good plan and we're going to implement it. If we kind of go there and let the legislature figure it out, we're going to be in trouble. So we need to have our ducks all in a row and then go to them and say, this is what we're going to amend the bill, amend the law, this, this, like the best possible program that we can have.
To add some of the data that you have from other states in terms of the numbers that we need in order to make this work. I think that kind of information is really helpful in terms of justifying the need to have opt-out. So I don't think we had that kind of data before. So this is like a specific change and amendment. So I think these are to focus in on that. So we can have data on what other states have done that helps as well.
Yeah, and at Pew, we have a model for modeling the financial feasibility of these programs based on different assumptions. So we can put different inputs to the assumptions and tell you, how long would it take before you'd be self-sustaining. I think that, the issue with this model is that we don't really know necessarily what the numbers of people would opt in, right? Like, so we're basing like the model itself when we talk about an automated savings program, like as it exists in the other states, like we're able to make some estimates based on what we've seen in real life, like for how many people will opt out of such a program. But in terms of how many people will opt into this program from this population, it's a little murky. So I think we would have a hard time like giving you a good feasibility analysis that we can count on, but we could probably develop something and give it a couple of different potentials and see how it would work.
Any other questions or comments?
Seeing as we don't have the data for the mandated programs for the state currently, couldn't we go back and go to corporate data? And they have data about opt-in and opt-out. And this has been going on for quite some time. So I think we could probably use some of that.
Oh, yeah, no, I mean, I think we could definitely use the data from the private sector. But I think we also have to like recognize that this is a little bit different than the private sector, specifically since a lot of the private sector data is based on employer matching. Like, and like, places like in private companies where like that was part of the sweetener was that employer match, whereas here we're just talking about an IRA and you're saving on your own. So, and again, we have no data about what happens when you have a $500 sweetener that comes a year later. We don't know. So I think we can probably do a couple of different analyses and say like, this is the low, medium, high, based on what we think.
But we do have a lot of plans with no match.
That's true.
And we can take it from a time period where they removed their match, such as 2007, 8, and 9, where employers cut off the matches as well. So,
okay, I'll take it back to our researchers and see what we can do.
Thank you. Very good question. Any other questions or comments this time? If not, why don't we go ahead and go to our next agenda item, which is overview of hiring consultants. Took the budget out of order a little bit earlier, so I will go ahead and skip over that and go to the program SAT. As we had mentioned earlier, there is positions and funding in the current budget and the new budget coming for an executive director, a program specialist, and a secretary 3. And our recommendation to the board for the board's consideration, the way we had conceived of the staffing for the program was to bring on the or the board to bring on an executive director. And then that person would be the person responsible for bringing around the other program staff. That would probably make the most sense to have that person hire the other two people who are going to help support the program. So is that something that the board would consider supporting?
I have a question though.
Sure.
When you look at the responsibilities of this person is in exempt position, you have a program specialist, but I'm not sure you're gonna get somebody at the quality and the competency to do what has to be done. This is a really big responsibility. So I don't know if that's program specialist 5 or whether, since it is an exempt position, looking at what the requirements are of the person. It's a lot of work and skill set that the person needs. So I'm just questioning, is that level of the position high enough?
You're talking about the executive director.
Yeah, you have an executive director, or is that a program specialist? Possibly executive director, is that this and what
Correct,
kind of
that's
salary range are you
Yeah.
looking at?
Yeah, so the executive director is the only exempt position, and that's the position description draft
This thing, and
that we did get approved, so that's that actual one. And for the board's consideration, and maybe related to this, we have that on the agenda to discuss
the salary range, so
the
that you can
salary
get
range, right?
the caliber you need for something.
Yes. Barbara?
To answer your question, I think it makes a lot of sense to bring on the executive director, and then that person will be responsible for choosing his or her staff.
Okay. Okay, so I'm not sure if that's something we have to, if the board needs to vote on, or if it can just be a discussion item. I'm assuming that's something that we can just go ahead and proceed in that fashion, right? Administrative thing, okay. Yeah, if that's all right. I mean, that was kind of our assumption in the department. We did establish the positions, and then we figured the executive director would come on and then detail out the position descriptions for the other positions. And then I think because it's a separate agenda item later, this discussion about what if there should the board take the position description that we drafted and put into place as is and go out and try to recruit somebody, or does the board want to look at actually maybe tinkering a little bit or making some changes in that position description, including the compensation level, and then turning around and recruiting? So that's something that the board should consider. Yes, Caleb.
I had a question about the education requirement for the position. That's on page 7. And it calls for someone with a bachelor's degree in specific finance or human resources areas. What's the thought process behind that, considering that this position is going to be responsible for getting a new program off the ground? And so you may want to, my thought is, from looking at this, is that you may want to have this be broader, because you're going to knock off a lot of people who may be well qualified, but who don't have these specific bachelor's degrees.
Yes, we agree. We've gotten the same feedback from when we made the position description available to other people, and I think it was Kim who had seen it and had emailed it and brought that same specific concern to our attention. So, up to the board, but I would think it might be a good idea to maybe take a look at changing this and working on that before going out and recruiting for the position, because we did the best job we could with the information that we had available to at least try to get something established and set in place and make it an option for the board, but if the board wants to amend this and have us do that and then go out and improve, we'd be more than happy to facilitate that.
Yeah, I mean, that was the only thing that I saw that I had any concerns about, and I really want to express appreciation to whoever at DLR, whether it was you or your staff. First of all, getting ahead on establishing the positions, which can take a long time, and then doing an excellent position description. I have, utmost appreciation and respect for your department and whoever did this. So thank you. Like I said, I have no other input other than what Keola had expressed.
Thank you, that's appreciated. And on our end, it was our human resources office that was very helpful, and then Kristen Lee from the director's office, who is also attached between on Zoom. It really helped with the position description. And one other item about the position description, we might as well go there and go out of turn in the agenda if necessary, is that our when I had the conversation with our deputy attorney general too, they thought maybe the introductory language, because it was so oriented around being in the director's office, that the board may want to consider making some changes there, because really in the long term, it's meant to be a freestanding attached agency or whatever. And I think for right now, it's in the director's office, so it's there. So that would be something else that we want to take a look at as well.
Just for some clarification, I do think that we need to have a person that can oversee all of the project and going forward. That I don't know if we asked for other organizations or other of the retirement savings programs in other states and what their executive director does and what the MQs are for those people, so that we can actually get that level and that caliber of people. I think we need to stand up this program.
Yes, we agree. And Kim had provided us with some information along those lines earlier that we can make available to the board or for those deliberations, because that is very. And I see we have a question from Angela. Go ahead, Angela.
I know. The only thing I just wanted to point out again, as part of the State Resource Center, and someone may have looked, but we in the Resource Center have all prior position descriptions used by other states. Also, if you just go to our homepage now, I believe, check, they still have, for example, Katie Selensky was the executive director of CalSavers. She recently left and they have posted for that position. So just off of our, homepage, you can see the job posting for the executive director of CalSavers. But again, we have those position descriptions if someone hasn't already looked through them. So you can see what the qualifications, background, and experience that other states have looked for in their executive directors.
Okay, thank you, Angela. Okay, so since we've gone ahead and moved on to the next agenda item, the recruitment. Yeah, sure. Sorry.
I was just thinking, is the board able to move and make a motion to amend the job description now so that you can begin recruiting? Because I would just recommend an amendment. I know I'm not on the board, sorry, just from the general public perspective. Maybe you could just end it at university with a bachelor's degree, period. I'm just trying to, thoughts on however you can move it forward quicker.
I like the idea of moving it forward quickly, but I guess if we do see what's, at least if you can look at it and give you the responsibility of looking at it on behalf of the board, so at least we don't miss anything, because I think this is a really important position, and see what CalSavers have, at least to look at what's there, and give you some license to make the changes so that we have a good person that and that it's not that we cover the bases. So I can see Kelly going further quickly, but I just want to make sure we do it.
In other words, you're saying we can delegate the responsibility to DLIR to,
At least we could move forward, you know, at least going out to recruitment, but, you know, I can see moving forward to go out to recruitment, but I'd like to make sure that we do due diligence with others that haven't done. If we can at least have you look at CalSavers, your HR person to look at, are we missing anything? Are we making it too restrictive? Everything, do we have everything there? That would be helpful to, if you haven't already done that, it would be really helpful to look at.
That's something we can look to and do an option, but I don't know. I think it would be better if the board actually deliberated upon it as opposed to us just doing it and then going to recruitment. I guess our comfort zone and the preference would be, and then this kind of goes to this is a new board and it's being spun up. And so the question is, how frequently does the board want to meet? What did people have in mind? Because we can go anywhere from, you know, we can go and make tweaks to the position description, maybe look at the compensation, or we can do it in a permitted interaction group, or we can do it as part of the regular course of board meetings. So.
Well, it depends on how often you're going to meet, and this is starting up, so you might want to meet more often, but you could have a pig or, you know, at least delegate it to someone on the board to look at and at least examine what others have done and come back to the board and, you know, have a date specific so that it's not, you know, for another couple of months out, but at least have some due diligence on what others are doing.
Personally speaking, I had anticipated that our meetings would be very frequent as in at least once a month. Is that something that DLIR has considered when you say, you know, we could, you know, do it as often as we feel we need to? I'm a little concerned because it seemed like even getting a date for this first board meeting was tricky because all of us have had trips and, you know, frankly, I think it's even harder when you have so many retired people because we tend to be away more than not. But if we were to have another meeting in another month or so, then I would be quite comfortable saying, you know, we can take up, you know, make whatever recommendations and then consider the completed job description for approval at the next board meeting.
So from the department side, we're willing and able to facilitate however the board wants to proceed as far as meeting frequency and everything. So even if you wanted to meet more than once a month or for a short period of time, whatever the board needs to move forward, we're here to help facilitate that. So that's really up to you folks. Really?
No, just what I heard Bill say is if you folks want to do that, the board needs to look at that content. DLIR isn't going to provide you the recommendations for amending the job description.
We're willing to help or be a part of that conversation for sure.
Yeah,
But,
no,
yeah.
that was how I understood it, but I'm saying if we give, you know, specific recommendations as we are now, it's like, okay, you take out the specific degree requirement. We can, you know, take out a lot of the introduction because it's not necessary to go into that much detail on what the director's office does. And then I'm not sure what the mechanism would be to sort of take a look. I guess this gets into some of the sunshine law, like how would we board members give our feedback? And to whom?
Can we have a pig? So some of people who are interested, like you've got the HR background, and we can ask staff to gather the information from Georgetown and then bring that to the board. Then come back to the board. But I think that might be a way of having some work done before the next board meeting.
Yes, we can have a pig.
Yes, Senator Morwan, or DHER director.
My understanding of my understanding of the provisions in the sunshine law are that you have to notice that you're going to have a pig, and we didn't do it for this meeting. So that's one factor.
You could have so So you could have delegate to staff at least collect the data from George Washington or Georgetown and others, and we bring it to us.
Yes.
But you can have a meeting more frequent, have another meeting posted. If people are willing.
A question about Sunshine. Suppose we were to ask DLIR's Human Resources Office to attain the position description for Cal Sabers director, understanding that they're at a very different point in the program. And I think that it takes it might not be the same focus on skills to be actually setting up a program versus operating a somewhat mature program, or certainly already implemented. But then if we were to get that, would that be something that could be distributed to the board members in advance of the meeting that we could ourselves take a look at and then give feedback to the Human Resources Office so that a revised position description could be presented to us as part of the board materials for the next board meeting to give feedback on and or approve? Or is that something that would violate Sunshine?
There is a provision for board packets. There is a provision for board packets so that the documents are distributed to the board prior to the meeting that we made available to the public.
So I guess practically what we could do is we set a date, time and certain for the next meeting, we could post whatever we wanted to do before that meeting, anytime before that meeting. And then the board could act at that meeting. So, or we could just post stuff on the website as resource materials for anybody to go look at. Maybe that might be the better way to approach it.
So it's open.
Right.
And we can delegate to your staff to meet with Georgetown and get the Georgetown from the startups to currently, so we can see what the requirements are for that.
Yeah, and I think from our end, I think when we posted materials, we could make that information that something has been posted, make that available to the board members as well. As long as it's available to the public, if I understand. And we have a couple of questions from our partners that are in the room. Tom, do you want to go first, please?
Yeah, thank you very much for that. I appreciate the comments as just made and the discussion. I would certainly not recommend establishing, even at a next meeting, a permitted interaction group, because the steps necessary for that actually would delay the decision making that you would have to do. So the way that you've just discussed it is far more efficient, both in your consideration as well as the information to the public. Thanks.
Yeah, that's a good point, because we had mentioned earlier, you have to not only notice it, but then the PIG has to report back and then at a subsequent meeting. So it sounds like the scenario where we make information available to the public and to the board members, and then we can duly notice that there will be a discussion, presumably a decision at the next meeting of the board for an amendment to finalize quote unquote that position description and salary. Angela, you also had a question or a comment?
Yeah, I was just, again, happy to help with the position descriptions. California, as an example, we have one that was first program director. So early stage, Katie, fill that position. And then we have the one that's currently posted. So you can kind of see the evolution with a program description like that. We also can share with you, Maine and New Jersey were two states that most recently hired new program executive directors. So those position descriptions as well that you can take a look at. I will say, in this job market, the experience with both Maine and New Jersey in recruiting an executive director took quite a bit of time. New Jersey actually used a recruiting firm to help them do it. It took them, I believe, more than 6 months. It might have taken them at least 8 months to find the executive director. I will say the executive director is an incredibly important position. If you don't find the right person and things don't work out, it's a setback for the program. And there are examples of that. So happy to have a discussion with someone more specifically about that, but it is an incredibly important decision. With respect to board meetings, I think this is probably pretty obvious, but for states when they first launch, depending on your date by which you need to launch, generally the boards are meeting on a monthly basis. And then once they get through to full open to all eligibles, then they tend to downshift to a quarterly basis. But usually that first 18-month period, there's very frequent board meetings, often as frequent as monthly.
Thank you, Angela.
Sorry, I think I actually, a lot of what I was gonna say overlaps with what Angela was saying, but I will note that Delaware was a recent, like they did a recent recruitment for an executive director in Delaware, which is a state that's of similar size to yours, so might be worth looking at the Delaware one, but you know, if I'm honest, like for your position description, it's good. Like I think, you know, it's probably worth looking at these other ones, but like there wasn't anything there that stood out to me as something's glaringly missing here. So, you know, like take that with a grain of salt, but like I do think that moving more quickly, like maybe to your benefit.
Okay, thank you. So it sounds like the consensus is we'll make information available online at the website and notify the board members that it's available there, and we can have a discussion at the next meeting and finalize, make a decision, finalize at that time, and then go out with the recruitment. So maybe now would be a good time to, well, let's touch on the evaluation and the feasibility study of the program. So whether that's the department doing it on its own, helping the board go out with the parameters of this study, because it does need to be done relatively quickly, and the money is in the next fiscal year, which starts July the 1st, or whether or not an executive director is on board to help facilitate that. Excuse me, sorry. That's something else that is, you know, front and center before the board as far as proceeding in addition to the executive director. So yeah, I don't know if there's any thoughts or questions or comments about that, but that's also something that is going to need to be procured. Okay, seeing none. Actually, Gil or Barbara, I'm sorry.
Do you have the staff now to run a procurement for this consultant?
Yes.
I'm so impressed with your department. Truly, thank you.
Well, we want to try to help facilitate. I mean, when you say staff, you're looking at them, so.
Thank you for being honest about having the ability to do it.
Well, we're willing to try. I mean, I don't have that much personal experience with procurement, so, but we try to help. I mean, we certainly wouldn't want the lack of an executive director in the short term to interfere with, you know, we don't want to tell you that you have to have the cart before the horse or whatever. So if that's what we need to do, that's what we will do. But the preference would be to bring an executive director on the board to really help shepherd that all through, because really, I think when we look at the executive director and when the board does hire that executive director, I think that's someone who needs to have some navigational experience with the in-state government and the state laws, including procurement, sunshine, all this kind of stuff. You know?
What kind of parameters would we need in place to for you know, setting the scope of the RFP?
What exactly do you mean by parameters?
Like, you know, what is the scope of this study? Like, what do we need to make sure is in the RFP?
That's a good question. I think you have to reference the existing statute. And I think in those deliberations, I think you're going to have to come to some conclusions about what exactly those mean. And also, you know, there's been some discussion today about what, you know, should this be a certain kind of program or another kind of program? Should opt-in be looked at? So all of that stuff needs to be contained, I would think, in that proposal or in that scope for that proposal to go out, so. Yeah,
So it sounds like as a board, we might need to have to come up with some ideas for what needs to go in here and then bring that to the next board meeting.
yes, that would probably be good. And then, we'll also make available, we did have, because we had a legislative proposal for this past session that we had as part of the department's package for the governor. In a discussion with the stakeholders earlier, we kind of pulled back on that because it was maybe premature because the statute that passed, or the law that passed, actually had set this board up to start meeting in October of last year. Everybody was supposed to be appointed, and then, you know, it was a transition year for both the executive branch, the governor, for the legislature, and everything like that. So this board didn't form as fast as it had been contemplated by the legislature when it passed the law in 2022. So we pulled that back, and to give an opportunity for the board to actually go in and be involved with that instead of that actually being detailed out in the statute itself. Audrey?
Yeah. So in terms of the evaluation and study and feasibility study, the way I looked at it when the legislature crafted this was basically a business plan. And so there are some elements in the language of the statute that tells what has to be in it, but more or less how I looked at this particular report was really a roadmap of how this program is going to be implemented. So I think it's very critical that you have an executive director on board who work hand in hand with the program consultant who's going to do a lot of the legwork. And there's a lot of research, but there's also components of marketing, staffing, and some of the costs. So it's a complex report from what I'm reading, but nevertheless, it looks like a business plan.
Yeah, it's a very good point.
Period that we have to advertise the position for.
It's an exempt position, so there doesn't need to be a advertisement period at all. The board can just go ahead and select and appoint.
Actually, the interesting question to me is whether or not we do engage an outside firm to help with the recruitment, do an executive search.
Yeah, that's probably a good idea too. I mean, I don't know.
Again, we have funds that we can use for that. And then two questions, do we have the funds? And then do we have to go through procurement to select the firm to do the executive, search?
So yes, there is funds that can be used. And yes, you have to go through.
So we prolong the process.
Welcome to state government.
But we could post the job description and also then pursue procurement for a placement agency.
Yes.
Can do both.
Yes. And one of the options is to post and to hire with the understanding or with the intention to amend the position description on the fly as well. So, I mean, there's a lot of flexibility in how to approach it. I don't know if that's the best practice to hire somebody under a position description that you don't intend that you intend to change, but I mean, that's up to the board, really.
Can I suggest staff to check with the state procurement office and see what we can do to expedite, but also be within the realm of procurement it's a consultant, basically hiring consultant firm, and maybe you could do it faster because it is exempt and it is administratively attached.
Yeah, we can check that, and but also the state procurement office also has pre-existing contracts and lists for things too. So there might actually already be something that we can tap into that's already part of procurement to do in executive search. So we can certainly look into that and report back to the board. Yes, Audrey.
Curiosity, what is the salary range?
The salary attached to the current position description is up to $100,000.
Up to it.
$100,000.
That's not gonna do it. And it includes benefits, plus benefits.
That's just the salary, but the costs involved would also entail the fringe. Yeah, so I think the fringe is 64%, 63%, something like that right now.
So what do we as a board have to do, if anything, to ensure that that's not the salary? Because we all know that we won't find the right person for $100,000 in salary. Is there a process, or knowing that it's an exempt position and we certainly have flexibility, but budgeting being the question and available funds?
So, yeah, the flexibility is there. The budget might be a little bit challenging, but there is some flexibility with the appropriation that we have. So if the board wants to make a recommendation about reallocating some of the defined categories for the appropriation, I think that's something that we can look at and talk to budget and finance about it. And probably one of the reasons why the budget and finance director is formally a part of this, because I think the legislature confidence this was going to be kind of a complicated enterprise to spin up and roll out. Yeah.
You don't have to go out and then you don't get anybody, so that prolongs the process again. So you really should be looking comparable. And Georgetown might have a comment.
Angela, you have a question or a comment?
Yeah, hi. Just listening to the discussion, just by way of background again with Maine, New Jersey, and recent hires. I think Delaware, it might be a little bit less, but the range right now for those salaries are running about 150 to 165,000. California is at least at that level for the recruitment now.
Thank you. Okay. Any other questions or comments, Karen?
So based on that, are you going to look for money someplace else and tell us?
Yes.
Where we can get money? Okay.
Yeah, the money would have to come from within the appropriation for this program. I think that's a matter of reallocation. Okay, so maybe we can segue into the next the sub item on the agenda. Yeah, sorry, Kayla.
So we have this budget that was in the slide deck. Do we have more detailed line item budget? If we're talking about reallocating.
Yes, so there is actually, what we can make available is the budget worksheets, which shows the breakout of the total appropriation that was made by the legislature.
Okay, yeah, that might be helpful for the next meeting so that we can figure out how to set a competitive salary.
I believe there may be reference material available as well. Yeah, so the way it reads right now is that there's 15,000, I'm sorry, allocated for travel in the next fiscal year. There's 2,000 for computer and software licenses. There's $1 million for the actuarial study. And then there's a breakout of, I think it's about 255,000 for the staff salaries.
So for the other board members, it's tab 4 in the board binder.
Maybe a question for Louis, but to me, the question really is which categories can we
access for the allocation.
Yes.
And
Yeah, I don't think there's any great impediment there. There's a lot of flexibility in how the board or the department allocates the amounts. Brian?
Yeah, just a quick question. As far as the feasibility study, evaluation of feasibility study. Yes, I'm kind of wondering how the board is taking that. In other words, are we looking for that study to help justify whatever changes we have that we're going to make to the law? And so that we have to lobby next session. In other words, we have the study, will be done. I guess we'll have to discuss what kind of parameters we would want to do based on the study. And then we'll probably have to take a position as a board to go to the next legislature and lobby basically to, amend the current laws to reflect whatever things. So in other words, I think the study got to be done relatively quickly. And if we want the executive director to be on board prior to the I guess study being done and help lead the study, then we probably need to move really quickly on hiring, setting it up so that we can have the time necessary to do this. We can't start lobbying on the first day of session. We have to lobby prior, a month, maybe 2 months prior to that. So I'm thinking just into my head, I'm thinking, wow, we're gonna, I think it's a good idea to have the executive director on board. I know that there's procurement issues that come up because of things that we have to do. And if you want to consult it, that's probably the best practice, but in terms of time, that's kind of rough. So, and then the time it would take to do the actual study. I'm thinking the study has to be kind of compact because if we're going to make recommendations to us for what kinds of amendments we're going to make, then like I said, we got to kind of discuss it and be sure that that's what we all agree upon. That's going to take at least one meeting or two, and then have to set up our lobbying schedule. Although I know Senator Milwaukee's going to ram it right through, but anyways, I mean that's what's going in my head. We got time and stuff. We got to kind of hit pretty quickly, and the time's just going to evaporate.
So are we board members willing and able to meet in another, when can we next week? Was it 2 weeks? Is it 3 weeks? But it sounds like we we really need to
Take up the calendar and look now.
get another meeting on.
Do we want to have a discussion about when to have the next meeting now?
Is there something we're looking at, what is the scope of work, right? Or what needs to be done? So there's this part of it, which is, do we need to amend the law as it reads now? Or do we need to have a scope of what is it that we need to do in this program? And then that might be, some things might be by rule, doesn't have to be by statute. And so I'm just thinking, is there some place that Audrey mentioned, this business plan? I think it's some kind of business plan of what all the ducks are that we need to have on board to line it up. But the other part of it is, if we're going to do an evaluation, it might be premature to do the evaluation. Maybe we have to set the parameters out. And so I think maybe some discussion on what should that study be, meeting closer in time, and then proceed, because some of it can be done in sync with getting a person on board, because we're setting the parameters of what this program is going to be. So I think that might be helpful to scope that out. What are the needs for this, standing up this program? Some might be legislation, some might be by rules, some might be administrative. So.
Do you have a tool for surveying all of us on our availability for different meeting dates? Like way back, a long time ago, Doodle was the one that everybody used. I don't know if that's used. Or, I mean, I don't know, I don't know how easy or difficult it will be to set a date when everybody's available, and is that something we do? Well, is that something, I don't know, I don't know if that's when we do that.
We do have, we can look at using a tool, whatever kind or whatever. I would think it might be good to go ahead and try to set a date and time now.
Yeah, are we able to, is everyone able to set a date and time now? Do you have your calendars? Yeah, I think it's gonna be much faster and work better.
My thought was that I don't know if this is a good day of the week and a good time, but whatever, might be a good idea moving forward to look at setting aside the same day of the week and the same time. And then for future meetings, it makes it a little bit easier if you've already had that blocked out for everybody. So if we look at,
One of the things is that if you can't meet in person, I think you can meet, if you notice it, you can meet on Zoom, but you have to be, you gotta be a picture of, you gotta be there, not just by voice, not by phone, but actually be visible that you're there. So, I think it gives some flexibility and being able to meet Zoom.
yeah. And I think now that we've kind of moved forward a little bit more in time, for one, and personally, I'm very appreciative of being able to have in-person meetings and not talk at everybody through my computer. So I think on our end, we'd appreciate as much as possible for everybody to be in person, but if you cannot, it's not a problem to, technology is very easy, and in order to facilitate things, we're more than happy to do that. So I don't know if you folks want to look at June, Thursdays, afternoons in June, but I believe
June 8th is in 2 weeks.
yeah, 8, 15, 22, or 29 are the Thursdays in June.
What does June, if we were to meet in 2 weeks from now, that'll be June 8th.
Yes.
Good for me. Can we look at maybe the 15th of June? That's a little bit.
That I cannot do. June 15th.
Not even Zoom.
Not even Zoom. I've got an all-day meeting that I cannot reschedule.
How about the 22nd? That good for everybody?
Zoom. Zoom for me.
Okay.
I think that might be off.
Okay, so why don't we go ahead and we'll schedule it for the 22nd of June then at 1 p.m. And we will confirm the availability of this room, and of course, we will also do it. Yes.
You want to try to
Everybody wants to try June 8th, we can.
I have a 5 o'clock that I have to do, so I have to get out of here.
How long is
Probably
it?
4 o'clock at the latest.
2 hours.
Really up to you folks. 3 hours seems kind of long.
we would have all this stuff on the agenda. Yeah, mostly just
It's just a key item.
we could shoot ourselves to make it up.
Right.
Well, yeah. If we can go from 1 to 3:30, that would be ideal. That's 1 to 3:30, that's 2.5 hours.
Oh, 2.5.
Yeah, that should.
Okay, and then there's nothing that, I don't believe we have to meet the whole time either, so if we conclude earlier, that's okay too. So why don't we go ahead and we'll try and we'll notice and do an agenda for June the 8th at 1 o'clock? 1 o'clock, and then we lead to 3:30.
When's the date again?
The 8th of June. Oh,
You can't do that.
except for, I'm sorry, the 8th of June. I cannot.
Oh, you cannot do.
Oh, yes, and Jade, you and Jade will be gone.
Both the director and I will be gone.
When
Sorry.
How about this, what is that, Tuesday, that we, we can see to make other days. Monday? No, that's the fifth is a holiday, it's coming up. No, it's not a holiday, you said June fifth, it's not a holiday, really?
Did you just make it one? You could do.
We want to try June 5th.
Question for the deputy AG, is the discussion about scheduling, does that have to be part of the public meeting, or can we end the meeting and then have our discussion on when our next meeting is?
We can put in the. You could end.
Yeah. Yeah, as long as we public notice it, then I think we can, yeah, it doesn't matter. I think for convenience sake, we're just trying to do it.
Yeah, no, we're doing it now.
Let's do it now. Don't
We
have
have
to
to
worry.
finish the meeting, we still have.
Yeah, we still have public comment.
Okay, so if that's all right, then maybe we can move on to public comment and announcements, and then maybe at the end we go into item number 8 about the boards. Okay, so do we have any comments from the public or questions? I'm seeing none in the room, and at this time I'm not seeing any via Zoom. Okay, Kaylee, you have a question in?
No, just comment. I wanted to thank Director Boutte and you, Bill, for really, and Nancy for doing such a bang up job in preparation for this meeting, but also, so you folks all know, a lot of this program would not be possible without the LIR's willingness to take this on. And I've just been very impressed with the work that you're doing, both with the board meeting, the website, and pulling things together. So I just wanted to make sure that got said, and just thank you for the amazing work.
Okay, so seeing no other public comments. So we're tentatively looking at maybe the first full week in June for the next meeting, and we will confer and duly post that according to the provisions of the Sunshine Law. And that leaves us with only one item left on our agenda, which is executive session. So I believe that's something that there needs to be a motion for, and seconded and voted on by the board in order to go into executive session.
Those that we go into executive session.
We don't need to go into executive session. We just wanted to make that available in case there are any questions that you wanted to ask of the attorneys at this time. And if we don't need to do it, then we don't need to. So if the board doesn't feel it's necessary at this time to have any discussion with our attorneys, then we don't need to do that. Okay, so if there's nothing else, then we'll go ahead and end the meeting. Thank you very much, everybody. It's much appreciated.